Can you see my screen?
Yes, we can. Can we begin?
Yes, you may.
Thank you. Welcome to day 2 of the 18th annual IP and Social Justice Conference. I'm Esther Lim, a partner of Finnegan. Year in Review is one of the perennial highlights of the conference and an informative and entertaining survey of patent, trademark, and copyright cases. The audience is welcome to submit questions in the chat box throughout the panel. Kicking off this terrific panel is Tom Irving, also known as the Wizard, who needs no introduction. Tom has been with this conference since its inception. His high energy talk provides a glimpse into his 4+ decades of remarkable patent practice. He is much sought after by clients across the globe for high stakes patent matters. Tom, thank you so much for joining us. The floor is yours. Tom, we are unfortunately not able to hear you so far. Ronaldo, can you confirm that Tom is unmuted, please?
I am on it.
Can you hear me now?
Yes, we can, Tom.
Okay, my name is Verizon. Okay, let's go to slide 5. This is the Arthritis Case. And in this case, the Federal Circuit held that the PTAB judges were unconstitutionally appointed, which struck home to me because one of my son-in-laws is a PTAB judge. I hope he kept the job. And so basically, it ended up in the Supreme Court. It was heard on Monday, March 1st, and here's my prediction. The Supreme Court finds the judges were indeed unconstitutional. They will find a way around it. And my only question is, and we'll see when the decision comes out, will it be retroactive or not? Okay, let's go now to slide 13.
I'm sorry, Tom. I'm having some issues hearing you. I don't know if everybody else is having as well.
Yes, there's a similar issue.
Can you hear me now?
Yes, go ahead. It's a little bit clear.
Okay, I'll get real close to the computer here and go along. So on slide 13, please. Etiquette disclosure.
Tom, unfortunately, the sound is not coming through. And several of the audience members experiencing the same issue.
What would you suggest? I am
Is it possible perhaps then for Chip to go ahead with his trademark presentation while your technical issues are resolved?
Yeah, then put me last.
Absolutely.
Okay, there's Chip's slide. Well, you'll first hear from Chip Rettew, who's a partner of Finnegan specializing in trademarks. Chip is widely recognized as one of the best trademark litigators in the country with an unbelievable success rate. You're about to see and hear why Chip is a go-to litigation lead for world-famous consumer brands. Like Tom, Chip has been a staunch supporter of this conference. It's a delight to turn the floor over to Chip.
Well, thank you, Esther. I think this is the can you hear me okay?
Yes.
All right.
Yes.
I think this is the first time we've been unable to hear Tom ever. So let's make sure we record that. So thank you for having me. It's a pleasure to have everybody here in my home as we now do. I have to tell you, now that virtual presentations are becoming a norm, I did a presentation last summer to a group of Canadian lawyers, and I wasn't here in DC. I was up in New Jersey, and the background was a bedroom, and I had our bed, and I made sure I made it nice so everything looked good, and because I knew the room would be on display with these hundreds of people watching, and I didn't realize in the middle of the presentation my dog went up on the bed and just started ravaging the pillows. So at the end of it, I looked, and the bed was a complete mess, and so I was just so disappointed that everybody probably thought like this guy can't even make his bed for a presentation. So now I've got a bookcase, which, while not as neat as others, is acceptable, I hope. So it was a big year for trademark law. We have 2 trademark cases that went to the Supreme Court. And I think because our conference is touching on social justice, I think these cases certainly touch on social justice issues, which we'll talk about. And so let's look at the next slide, please. And this is a Supreme Court case. And what hits on social justice is big damage awards, right? This is what puts people out of business. And in trademark cases, it's often difficult to get actual damages. So what we do oftentimes is demand the other side's profits. That's the big monetary deterrent in trademark cases, and that's where typically, not always, typically you're going to get the most money vis-a-vis monetary relief. So there was a question on whether or not, what do you need to get the other side's profits? And so the Supreme Court took that case up. Here it involved a company called Romag, and they make fasteners. And what I love is, most of the Supreme Court cases on trademark that take up trademarks take it up on these obscure products. Qualitex, the color case, involved press pads for dry cleaners, and Traffics involving functionality and the interplay between utility patents involve these street signs. And none of them involve, or very few involve, a product that we see every day. But as the case is, Romag involved these fasteners. And what they are is these magnetic fasteners that you typically have on handbags so that they just close. So Romag supplied these to a bunch of people, one of which is Fossil, who makes various products. And they learned that the Fossil factories were using counterfeit fasteners. So they sued them in the District of Connecticut, and for trademark infringement and for counterfeiting. Next slide, please. All right, and so the district court went to trial, and the district court found that Fossil was liable and that they acted with callous disregard for Romag's rights. However, they did find that that was not willful. And why was this important? Because this is the District of Connecticut, and the Second Circuit was one circuit that required willfulness for an award of profits. Now, the case then appealed to the Federal Circuit, and the decision was upheld. Now, what was quite interesting at the Federal Circuit is the Federal Circuit looked at this and said, look, we have to apply Second Circuit law on this trademark claim. And so the Second Circuit, as I mentioned, is one circuit that required willfulness as a predicate for obtaining a profits award. They, along with the Sixth Circuit, the Eighth Circuit, the Ninth Circuit, and the 10th Circuit. That's not the case everywhere. The Third, Fourth, Fifth, Seventh, and First Circuit have different tests that did not require willfulness. So this set the stage to take it to the Supreme Court. Next slide, please. All right, so the issue here was, as I mentioned, do you need willfulness to get an award of an infringer's profits? Very important, because as I mentioned, profits are a simpler, easier, and more common way of getting monetary relief. So the Supreme Court, as it does, looked to the statute. And the statute over here, you can see on the slide on the left-hand side, is section 117A. And the statute says when a violation of 43A or D of the title, or a willful violation under 43C. Now, 43C is dilution, is established, then the plaintiff can get the defendant's profits. So the Supreme Court said, look at the statute. The statute itself has a willfulness requirement for dilution, but not the other things, not infringement, and not unfair competition, and not cyber squatting. So therefore, willfulness should not be read into a statute when it's not there, particularly if the same section has willfulness in there. So let's go to the next slide, please. And the court also looked beyond that particular section of the Lanham Act. They looked at other parts of the Lanham Act and said, look, intent is present in various parts of the Trademark Act. For cyber squatting, there's an intent requirement, or at least a good faith requirement. There is statutory damages for counterfeiting, mentions intent. Destruction of goods as a remedy mentions intent. And there is under section 1114, there's a safe harbor for innocent infringement for publishers. So the court said, look, Justice Gorsuch said, the Lanham Act is very clear. When it wants intent in there, it puts it in there. It didn't put it in here, so therefore willfulness is not required. The court was careful to note that the mental state of a defendant is relevant, but it's not required. Now, what's very interesting to me is Justice Sotomayor issued a concurrence. And I always love her opinions on this stuff because she was a trademark lawyer. People don't realize she worked for a law firm in New York City and did a lot of trademark focused cases. And she issued a concurrence saying, look, I agree, willfulness is not required. But she also said, when you have good faith, you should not have an award of profits. And she said that the majority was agnostic on that point. They didn't take a position as whether good faith could shield you from an award of profits. She thought it should, and therefore concurred in the opinion. So that's very interesting. She said that is not consistent with equity. So next case, the next slide is Booking.com. And this is the second case that went to the Supreme Court this year. Just as a disclaimer, I did an amicus brief for a group of professors on the case advocating for the protection of Booking.com. And that's the way the court went, fortunately. So another very interesting issue here, and that is, if you have a generic term, and we all know that generic terms are not protectable, but if you have a generic term like, in this case, booking, for a website dealing with booking travel vacations, and you combine that with a generic top-level domain like .com, can the composite be generic or can it be protectable? And so let's go to the next slide, and it shows us that the Trademark Trial and Appeal Board said, no, you can't. They found that was generic. It didn't have secondary meaning. And then also it's merely descriptive and in the alternative. The case then got appealed, because you can appeal a TTAB case to the U.S. Court of Appeals for the Eastern District of Virginia, or to a district court, or the federal circuit. But if you go to a district court, you can then add new evidence, and that's what the Booking did here. They went to the TTAB, I'm sorry, the EDVA, and the case was before Judge Brinkema. And there they introduced evidence of survey evidence, as well as evidence from a linguist. And the survey was very persuasive in showing that Booking.com was perceived as a source identifier. So Judge Brinkema reversed the board and said, I think this can be protectable. She said it is had acquired secondary meaning and is protectable. That then got appealed to the Fourth Circuit, who upheld the rule. Then the USPTO petitioned for certiorari, and that takes us to the Supreme Court. And the next slide, please. All right, and so the Supreme Court examined the issue, and they really focused on consumer understanding, evidence of consumer understanding, and not a per se rule, because the PTO had advocated for a per se rule. If you have a generic plus the generic, in this case the GTLD, that the composite's generic. And the court said, no, we have to look at consumer understanding. That's what drives the genericness inquiry. Do people see this as the common name for a genus of goods or services, or do they see it as a source identifier? And so simply put, if we look at number one, the court said, do people understand Booking.com, right? Or do they understand booking sites like Travelocity as a Booking.com? Right? Because that would be, if Booking.com was generic, that's what it would be. And second, people searching for reservation services, would they say, hey, tell me what your favorite Booking.com is? The court said, no, neither. People don't do that. And therefore, Booking.com in this particular instance is used as a source identifier because people know it to be coming from one producer. Interestingly, part of the briefing was that there's a lot of inconsistency at the PTO. Some .coms were protectable, some .coms are not, but this certainly cleared it up and paved the way for protectability of these types of marks. All right, next, let's go to the next case and next slide, please. This is a great case. So this is a case involving fair use and parity. And so what it is, as you can see on the right, many people know Jack Daniels. And the defendant made a dog toy called Bad Spaniels on the left, right? So there's this dog toy that looked like the Jack Daniels bottle. What I love about this is not only do they have Bad Spaniels, but they had, and you can't really see it there, but the alcohol content. For the alcohol content, they had 43% poo by volume, 100% smelly. So just fantastic. But and it's only trademark cases that you could say poo, and it's totally fine. They also made things like Mountain Drool and other parody products. So Jack Daniels was not all too happy about this, and they sent demand letters. The defendant filed a declaratory judgment action. Now this is a very interesting issue because we know that you can have parody for things like Mad Magazine or Saturday Night Live because they're purely expressive. Some courts, there was the Walmart case where they said if it's a T-shirt, even if you sell a T-shirt, that could be fodder for First Amendment because it's an expressive product. But there are other products like this which are not necessarily there to send a message. They're there for commercial profit. And so it creates this kind of tug of war, and I think to our theme of social justice, on whether or not there should be a right to express opinions or mockery through commercial products. And this court said you can. So next slide, please. All right. So what happened was the district court actually found infringement, and they ruled for Jack Daniels. The Ninth Circuit, though, reversed. And one of the arguments, first there was the fair use defense, right? So the defendant argued, hey, this is a fair use. I'm just using this trademark to identify what it is. Court said no. Both the lower court and the Ninth Circuit said, no, you're not using the trademark, you're modifying it. It's different. And for fair use to exist, nominative fair use, you have to use the actual mark that is the plaintiff's mark. So fair use, no. But First Amendment, you do have something, right? And so what the court said is, well, I love this line. The court said this Bad Spaniels is admittedly not the equivalent of the Mona Lisa, but is an expressive work. And the court found, even though it is a commercial product, it is an expressive work. It juxtaposes the seriousness people have for their animals and their pets with this kind of whimsical juxtaposition against commercial products. And so the court found, and also relied upon a decision it had, as many know, there's that honey badger YouTube video that's all over the place. And there was a Ninth Circuit case saying you could use the mark honey badger on greeting cards because that is expressive. And so the court said it is artistically relevant to the underlying work. And in that case, the question is whether it is explicitly misleading, which is the Rogers v. Grimaldi case, articulated by the Second Circuit, which a lot of courts use for expressive works. And so the court remanded the case for that. And let's go to the next slide, please. Then we have the dilution case. And this to me was very interesting because the dilution statute has an exception for non-commercial uses. And the court said here, this is non-commercial, even though it is quite literally a commercial product. And the test there is, does it propose a commercial transaction and does it contain protected expression? And the court found, because of the protected expression, using this toy to convey a humorous message, it was protected by the First Amendment. This is consistent with a Fourth Circuit case called Chewy Vuitton, where actually another dog toy case, where the defendant was able to use Chewy Vuitton over Louis Vuitton's objection and lawsuit. I suspect this went into the Ninth Circuit not only because of the party's locale, but there was Ninth Circuit was the best circuit before this for these types of cases, because there were some cases that went the other way. So, but no more now. So sticking on the issue of First Amendment, let's go to the next slide and next case. And as we speak,
before we proceed, we have a question, if it's okay, if you want to answer it, from the chat. It's how important do you think the strategic decision appeal under 1071B was to the Bookings.com case?
Very. I think it was very important because by doing it under 1071B, more evidence could be introduced at trial. And so that gave the opportunity to supplement the record, and I think that swayed the Fourth Circuit and the Supreme Court. So I think that was a significant driver. Also, the fact, and I think the answer probably is it was very important because the results bear that out. But I find, there are times when I've taken over TTAB cases, and if the record is not robust, it is often good to appeal under 107(1)B just for that very reason on the evidentiary basis. So I think it was very important, in fact, critical, I think. So great question. The next case involves the Call of Duty game, which my son right now, my high school son, probably is supposed to be in class, but is multitasking in the basement playing this as he's listening to lectures. So, and I'm from what I understand, we're not alone in that. But GM makes the Hummer vehicle, the well-known Hummer vehicle, and the video game Call of Duty features the Hummer vehicle because it's something that is used in military operations. Next slide, please. And so you can see a picture of it. There's the video game with the Hummer in, and AM General, who owns the brand, was not happy about it. So they sued Activision, saying, look, this crossed the line. You're using the Hummer too much. People are going to think that we have something to do with it or that it's licensed. Next slide, please. And so, again, we come back to the Rogers v. Grimaldi case. And the analysis is whether or not the use of the brand, in this case, the configuration of the well-known Hummer vehicle, is artistically relevant to the underlying work or expressly misleading. Now here, I think GM probably said, or AM General said, I think we got a shot here because they did a survey showing that 16% confusion from consumers. Now 16% is an amount that many courts find actionable and significant. And the court here said, okay, well, that's fine. You have confusion, but because we are looking at the First Amendment Rogers v. Grimaldi analysis, does that make it explicitly misleading? The answer here was no. And in fact, the court found for Activision, the video game maker, on summary judgment, which is very significant. And so it really does show the power of the Rogers v. Grimaldi analysis. All right, next slide. All right, this case involves Pocky, or I don't know if it's Pocky, I think I'm pronouncing it right, but I've seen this food a lot and I love it. And honestly, these things are just awesome. If I could, I'd eat these things all day. It's this, I don't know if people know, it's these sticks, these cookie sticks that have chocolate on one side. And so what happened was there's a company who has made these in 2000, well, for many, many years. They made it since 1978 in the US. They had 2 trademark registrations for the configuration. The defendant, as you can see on the right, Lot, started making the same sort of cookie. Now, interestingly, the plaintiff, Pocky, the Pocky folks, objected back in 1993 to 95, and then they let it sit for 2 decades, which is kind of interesting to me. But so be it. But the case eventually they sued and went to the District of New Jersey. And the question is this configuration of this cookie protectable? Next slide, please. And what the plaintiff argued was, in order to be functional, it has to be essential to the product. The defendant said, well, it's not essential, it should be useful. And the court looked at this and said, all right, well, let's look at the word functionality. Let's decide this. And they said, obviously, you have to look at the patent statute because trade dress, you don't want to provide a perpetual patent via trade dress or trademark. So we look at what the patent statute says, and that protects new and useful articles. And so therefore, the court said we should look at whether something is useful, not necessarily whether it is essential. And the court noted that useful is, in their words, a far cry from essential. And interestingly, the court said, I love this line, they said, we are careful to keep trademark law in its lane. So that was very interesting. And so you can see kind of 1 through 4 here as the test on how to assess functionality. Next slide, please. And so how does that apply here, right? And so the court looked at it and said, okay, number 1, you can see 1 on the upper left-hand side. The way this is designed is absolutely functional. It's designed so that you could have a number that is portable, they're small, they're thin. Second, you can hold the cookie on the bottom because it doesn't have chocolate. So it's easy to avoid sticky hand and it's easy to eat, hold, and share. If we go to number 2, the plaintiff advertised and touted that in its advertising. And that is something that is the kiss of death in trade dress. If you advertise the functionality of something, it's horrible. It kills you. And here they said, Pocky lends itself to sharing anytime, anywhere with anyone. So that really hurt. Now, there was also, as you can see in number 3, a utility patent, but the court said that's irrelevant because it was a method patent involving how to make these cookies, not necessarily the cookie itself. Fourth, the defendant or the plaintiff had come forward with alternative designs. They said, look, you can make a cookie any way and dip it. And they had nine instances of cookies that were dipped, but not entirely. And the court said, that's fine, but it doesn't matter. It's functional already. And I love the end of it. At the end of the opinion, they said, and this is not my words, but the court's, that's the way the cookie crumbles. But it is a very important case on the standard for functionality. So next slide, please.
This is just a reminder for a 4-minute mark.
Excellent. All right. Thank you. So I'm going to fly through as best we can. This is another very important case that got a lot of press. In this case, Tiffany sued Costco. And what happened was Costco made or sold engagement rings. And you can see here on the right, what they did is in the case, they referred to it as the Tiffany setting. Now, some of the, but they didn't put it on a box. They didn't put it on tags, but they had these little labels on the display cases. And it said, some of them said Tiffany setting, some said Tiffany style, some just said Tiffany. And the district court in this case really came down on Costco, found them liable, and awarded damages of $21 million in total. So this was on summary judgment. So it got appealed to the Second Circuit. Next slide, please. All right. And so what happened was, I think Costco did a very good job on appeal in focusing on the issues that for which there could be some evidence to support its defense, right? And so what they focused on were 3 things. 1, was there actual confusion? 2, was there bad faith? And 3, are consumers sufficiently sophisticated? And the Second Circuit analyzed each, and they said that basically Costco had raised issues of fact with respect to each of these. Now, this is what's critical here is, I think people don't realize on appeal, you have to look at the standard of review. Now, this was a summary judgment win. That's reviewed de novo. So it was fair game for Costco to argue whatever it wants. It was not they weren't burdened by a clearly erroneous standard of review or some other burdensome standard of review. So they were able to basically say, look, all we need to do is show that a fact finder could find in our favor on these particular points. Next slide, please. All right, and then there was also fair use, right? And Costco said, look, we're using it other than a mark, and therefore, and the court agreed. Well, a jury could find that this was just a descriptor, that it was not necessarily to refer to Tiffany rings, but to a style of settings. And in fact, Costco's other rings had their other signage, similarly situated, had generic setting styles as well. And then also on the issue of good faith, that is a highly factual issue. So the Second Circuit reversed and remanded back for trial. So big save for Costco. Next slide. All right, so I know I've got, time is short. This is an interesting case, went to the Federal Circuit. And the question here is whether a color mark can ever be inherently distinctive. Now, there is language in Qualitex and Walmart Supreme Court cases suggesting in dicta that a color can never be inherently distinctive. But there is also language in the Taco Cabana trade dress case that perhaps a color, if you logically apply the court's holding, could be inherently distinctive. So that was the issue here. Next slide, please. And the Trademark Trial and Appeal Board said, no, color can never be inherently distinctive. Federal Circuit reversed and said, no, that's not the case here. Now, here it was largely because it was a packaging mark. And I think that really saved it, that it was a color applied to packaging. And so really the key and the lesson here is you look at the color not in the abstract, but how it is applied. And here, again, it was critical that it was on a package because that is the language of Taco Cabana that saved it. And then also the Trademark Trial and Appeal Board said a color must be defined by a peripheral border. And the Federal Circuit said, no, that's not the case. Next slide, please. And the court looked at the Seabrook test. Now, this is a very important test for determining whether a trade dress is inherently distinctive. It's a Federal Circuit case, and you look at whether it's a common shade, whether it's unique or unusual, or a mere refinement of a commonly adopted and well-known form of ornamentation. And so applying that, next slide, please. Applying that, the Federal Circuit said, look, the board got it wrong, and it potentially could be inherently distinctive. And here, you got to look at the Seabrook test. You have to apply that and forget about this per se rule. And there's kind of a theme here between Booking.com and this, that per se rules are kind of going out the door. And the Federal Circuit vacated the decision and then remanded to consider distinctiveness under Seabrook. So I know my time is up, so I will, there's one more case in there, but it's in everybody's materials. And the long and short of it, it is a TTAB case that basically found if you try to register a mark for hemp oil extract, that does violate the FDA Act, the Food, Drug, and Cosmetics Act, and therefore you cannot register a mark if basically the product at issue, the product that you're identifying in your application, is barred by federal law. And there's a line of cases finding that marijuana and similar goods, either marijuana itself or accessories and things like bongs and things like that, are not registrable because even though some state laws allow it, the federal law still does not, despite the fact that the federal government kind of turns its head and doesn't prosecute those cases. If it's illegal federally, it cannot be registered, irrespective of what a state may say. So I thank everyone for your virtual time, and I think I'm just at my time, so I will yield the floor.
Thank you, Chip. Thanks for packing all of that in. Chip's practice deals with the coolest products and cases, and is certainly the envy of the patent bar. Thank you, Chip, for your excellent presentation. Next on deck is Ian Ballon, a shareholder of Greenberg Traurig. Ian is the co-chair of the firm's global IP and technology practice group. In addition to his practice specializing in copyrights, he has authored a multi-volume treatise on e-commerce and internet law. Ian grew up in Montreal, Canada, and has been practicing internet law since the 1990s. Ian, welcome to the program. Ian, you're on mute.
Thank you, Esther. It's always a privilege to be here. I appreciate being included, and thank you also to Professor Matima and to Tashia Bunch for this great conference. It's a great pleasure to be at Howard. My sister-in-law is a Howard alum. One of the lawyers in my group is a Howard alum, and this is always a great conference. What I am going to talk about very quickly is the year in review for copyright. And as I bring up my slides, I want to mention that I have included, let's see, here we go. Whoops, sorry, I am.
Can you see the slides? Ian, I put them up on the screen share.
Yeah, I want to bring it, actually, no, I want to bring it up myself. I'm going to run it from my screen. So
okay, let me stop my screen share then. Thank you.
Okay, thanks. Okay, all right. So so let me bring it up here. Hold on, sorry, having some difficulty. Maybe we should move to Tom, and then I'll come in last.
Tom, are you with us?
I am with you. Can you hear me?
We can hear you loud and clear.
One of the helpful chat people said, just get out of it and come back in. That seemed to work. Okay, let's go through this, and I'm going to end at, Esther, let's see, I'm going to end at 12:05, right?
Yes.
So I will do that. So let's go. Patent law year in review, U.S. patent law year in review. And evidently, it's better to be in the stars than to be the wizard. So this seems to go better. Let's go, Ray, to slide 5. The Arthritis Case, constitutionality of PTAB judges. Heard at the Supreme Court on Monday. Woo! Patent cases at the Supreme Court. This is a lot different than when I was growing up in patent law in the 1970s. And so what's going to happen here? I think it's very clear that it will be found to be unconstitutional the way the PTAB judges, including my son-in-law, were appointed, but the Supremes will find some way to save it. The question for me, I got a horse in the race here. I had a case we were fortunate to win at PTAB. It went up to Federal Circuit, and it got knocked back down. And so will this be retroactive? What's going to happen? We'll find out. Okay, Ray, let's go to slide 13, dedication and disclosure. And these other slides we're not going to cover. If you're having trouble sleeping tonight, read the rest of my slides. Okay, 13, please. Dedication, disclosure. Yeah, right there. Yeah. Oh, your numbers are different than mine. I see. Okay, now here, this is important in patent law. If you disclose something and you never claim it, you dedicate it to the public, which means you don't get any doctrinal equivalence. I got more to say on that later. So this case is really, really weird, and yet it's the established law. If you're going to disclose something, you darn well better claim it sometime in a continuation application somewhere. Now, let's go to the next slide. And this is where I put on my quiz show hat, because now we're going to have a polling question. So here's the question. If you disclose widgets, but specifically disclose and claim only blue widgets, without ever pursuing widgets in general or widgets of other colors in the first filed application or continuing applications, have you dedicated to the public all widgets other than blue widgets? Ray, if you'll turn the poll on, you get to vote yes or no, and we'll see the answers come in.
I'm wondering if the polling function has been turned on. Tasha? Thank you. You can access it in the chat.
Oh, great.
So I am seeing here a 75% for yes and a 70 for yes. Still moving.
Yeah, well, let's stop it there in the interest of time. So we've got 71-24, which in recent election terms would be a landslide. So 71% of you are saying, yes, yes, you have dedicated to the public all widgets other than blue widgets. Hard to say. I fudged this question a little bit. Did you really disclose widgets enough? But the main thing is, if you're going to say this patent application deals with widgets, make sure you claim a widget. And then you can also claim your blue widget. That came out well. Let's go to the next slide, please. Okay, now here, this is getting into the doctrine of equivalence. And this, to me, after having looked at this for over 45 years, is pretty darn fascinating. The Festo case came along and said, oh, you know, if you amend your claims and you narrow your claims, there's a delta, and you've disclosed and disclaimed all the delta. But there's some exceptions. And the 3 exceptions are here. Now, that one in the blue, don't try this at home. The dog ate my homework. That never works. There is no other reason. No case is ever so held. So forget that one. Now, the green one is interesting to me. Unforeseeable at the time of the amendment. Now, as we're going to go into right after this, a written description and enablement, whether I like it or not, and I don't like it, they are narrowing the scope of claims. And so now I see a real problem with this unforeseeability, because if you're starting to say, well, gee, it was unforeseeable, so, but therefore I'm entitled to cover it with my patent application, wait a minute. You didn't have any written description of that. You didn't have any enablement because it was unforeseeable. And so I don't think this unforeseeable is going to work anymore. And I also think Judge Giles Sutherland Rich, who I knew well, the greatest judge I ever thought in the history of U.S. patent law, he came up in the old Wilson Sporting Goods case in about 1987 in the Federal Circuit. He came up with hypothetical claims. I don't think those are going to work anymore because, again, same problem. If you come up with a hypothetical claim, you don't have literal infringements. You come up with a hypothetical claim that is infringed. Well, how did you possess that? How did you possibly possess that at the filing date? So I think we're going to see those things go down. Now, if you go to the next slide, there is one exception that works. And this is the idea that it's somehow tangential, that the amendment you made was tangential to the rejection. Now, you see three cases on the left there, Ajinomoto, Eli Lilly, and Bio-Rad. And you see one case on the right, Pharmatech. Now, I've looked at these cases carefully. I have no idea why the three of them were found to be tangential. The baloney is being sliced so thinly in these cases that I don't know how you really rely on this. It's always best to have literal infringement and not have to get into the doctrine of equivalence. And it seems to me that what may be going on the left here is a backdoor attempt by the judiciary to essentially kind of overcome the Supreme Court's ruling in Festo by broadening out the tangential exception. Now, I've supported Howard for 18 years, and I plan to do it for 32 more years. In the year 2053, I'm retiring. You're on your own. But we'll see what happens over the next 32 years as far as where Festo and its presumption goes. I do not know. If you go to the next slide, I put on an example of a successful tangential argument. Yeah, too factual specific. You can read the slides if you want. Now let's go over. I think our slides are off by one. So I think you want to go to now what is slide 22, Ray, if you would, please. Right there. Yeah, right there. Okay, now, this is what I just said. I don't agree with this because I've been practicing since 1975, right? I've been in patent law since 1975. But there's definitely a tougher standard coming down in cases for enablement and written description. And if you see there on the left, I put 2 cases, but then there were 4 cases that were really tough. On written description enablement. And you could say, oh, well, my invention is not predictable, and therefore everything is described and in my possession, and everything was totally enabled. Yeah, I don't think so. You're going to say your claimed invention was predictable? Has one ever thought of 103 obviouses? Well, if it's so darn predictable, how could it possibly be non-obvious? So I think that there's going to be a problem. I see things coming up on the screen. People would like access to the slide deck. If you can't get it somewhere else, it's on my LinkedIn. If you link in, I'll accept it, and then you can get the slides on my LinkedIn. You'll be happy to have those. Okay, let's go to the next slide. Now, here we go into the whole idea of, is a claim definite? And so, you're sitting there and you're thinking to yourself, okay, I got to write my claim. Now, when I was taught grammar in the 50s and 60s, and I was taught that it's important to write to be understood, but it's even more important to write so as not to be understood. Oh boy, it was the old hard line grammar in the 50s and 60s, I assure you. And so now here we are in the year 2020, we're still fighting in patent law over whether claims are clear or not. Are the claims clear? Are they clear or are they not clear? And so here you get, if there's multiple ways to measure without guidance, my co-author Stacy Lewis put in that wonderful little symbol there where it shows the poor person walking along and she sees, oh, there's 5 different ways you can go. Well, which way is it? Well, that is the key to having a patent come down because, as they say here, they use the term scored flexural strength. Who knows what that is? But it's not an industry term. And the specification didn't make it clear. And down they went. Let's go to the next slide, please. And again, if there's multiple ways to measure it, and if the issues come out differently, Oh, well, that can be indefinite. And here they remanded, Federal Circuit remanded, and they said, well, let's go back to the district court and let's review Mr. Higham's methodologies. And let's see whether the methods lead to materially different results. So, wow, you got to be careful with this. Now, the patent office has struggled with this in the courts. Next slide, please. So, basically, indefinites under 112. So, in AIA post-grant proceedings, they come up, and into the AIA, it's 112B. It used to be pre-AIA 112.2. Now it's 112B. So the USPTO approach in Packard says, oh, well, the standard is clear. Is the claim unclear? Oh, my goodness, unclear. But in the Supreme Court, in the Nautilus case, they said, whoa, if it fails to inform with reasonable certainty, then it's indefinite. Oh, my goodness, ladies and gentlemen. Is there anything clear about that standard? I don't think so. And then the PTAB came along in 2018, and they said, oh, well, let's go to the Phillips standard for claim construction. And so now going forward, the board will follow Nautilus. And again, I don't really see any difference. I don't really see any difference between Packard and the Nautilus standard. And so what difference does that make? Let's go, if we will, to the next slide, please. And now it's time for us again. It's time for another polling question. So you can see I'm obsessed with widgets. You disclose and claim an improved widget. There is no definition of improved in the specification or the prior art. And nothing in the spec compares an improved widget to a non-improved widget. You can't find an expert to opine solidly on what improved means. Here's the question. Will a U.S. court or a PTAB panel likely find that the metes and bounds of this claim are unclear and thus indefinite under 112B? Okay, Ray, let it rip.
It is up.
It is up. I get to vote too. Sometimes as a speaker, you don't get to vote. I love this. Whoa. Oh, good. I hate unanimity. That means I ask a stupid question. Okay, let's let it run a little bit more. People are, they're just scratching their nose. Oh, my goodness. It's on the rise. No is on the rise. Ooh, 80-20. Okay, let's stop there. We definitely have a winner or loser here. That's pretty clear. 80-20. But it's interesting to me that 20, and that's 22%. 22% of you said, no, that's not indefinite. I find that to be fascinating. And the others of you said, yeah, that is indefinite. And so, whoa, that shows to me, be careful. And if you're so lucky that you get to draft patent claims, do it carefully. If you're so lucky that you get to rip apart other people's patents, for me, I would much rather criticize the errors of others than defend my own. And I've made a career out of that. And so basically, you can look at these things and you can start playing with it and say, well, you don't have a problem with that patent. And if you even do a PGR in PTAB, you can raise 112B as a substantive defense in a PGR. So it's all very, very interesting. Okay, let's skip over now, Ray. And I do have my eye on the clock to see where we're going to go. I'd like to go now, please. On the original set, it was 32. That might be your 33. There we go. Claim construction fundamentals. So this is really kind of another way to look at definiteness, but it's claim construction. It is a preamble of a claim. It often says a machine, let's say it's a hair growing machine comprising a widget. Say, okay, is hair growing a claim limitation or is it not? Someone once quoted me and said, well, in Irving's experience, every time he wants the preamble to be limiting, it is not. And every time he hopes it is limiting, it is not. So it is like Irving never wins on this. So basically, you got to think about this and you got to really think, you got all that stuff there in the preamble. Look at that Biorad case. You're going to conduct a reaction in plugs in a microfluidic system, and Mylan, a method of increasing survival, comprising administering, blah, 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 blah. Well, you better, I think, the safe way to do this is either don't use the preamble and put in the body of the claim. Put in after comprising what you want to do. or somehow refer back in the claim, refer back to the preamble, where you say something like, wherein the method of conducting, blah, 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 and that gets you back to the preamble. That's the best way I know to do it. If you're going to use a preamble, that's probably the best way to do it. Now, what about? I mean, about, believe it or not, about can be a problem, because here it said the limitation is capable of being rotated 180 degrees. Well, you know, it didn't, alleged infringer didn't quite do it 180 degrees. They're a little high, a little low. And so the patentee says, but it means about. It means about 180. And that sounds like what Chip was saying about Justice Gorsuch, where he said, hey, if they'd intended that, they would have said that. And so be really careful about using about. It's not per se indefinite, but in my experience and over all these decades, it can sure cause a problem. And people say, well, just define it. But if you're going to define it, why do you need to say about? So I really believe that patent law is the thinking person's profession. And so you got to think about those kinds of things. Okay, let's go over now, Ray, to the Inequal Conduct case. I think it might be your slide 33 or 35. Next, please. There we go. Okay, now, here we go. Inequal conduct is alive and well. What happens when inequal conduct is found? It's basically something has to be objectively about for material, and it wasn't disclosed or something, and then there has to be a specific intent to deceive. That's the Theracense case. A lot of people thought when Theracense came down, it's over. It's over. We're not going to have any more inequal conduct. No. I'm doing a whole hour-and-a-half presentation on February 25th about inequal conduct and recent problems. So this is the disease. This is, the horrible COVID-19. This is the virus. It just stays there forever. People don't seem to get rid of it. Now, what happened here in this case, it's complicated facts. I don't want to go through the complicated facts, but if you go over, if you would please, one more slide. Go to the next slide. Yeah. And so there you go. March 2010 is the key date. The inventor gave a signed copy of this July 2003 proposal to Cantor Colburn. Now, they'd come in to take over this case from another firm. And so it turns out this was the killer. This was the killer because that was more than 1 year before they filed their patent application. So under even 102A1, there was no way they could get a 102B1A or a 102B1B exception. They were dead. And according to the court, now I wasn't involved in the case, and this is awful because they name names and make conclusions. The court, it says, they chose advocacy. They chose advocacy over basically honesty. And so the thing to do is to be squeaky, squeaky clean when you get into these cases. And if you've got troublesome facts, bring them up. Now, you would never do this. But what if you take over a case and you look into the file and you go, PU? I mean, I almost use the trademark term of poo, but according to Doug, that's limited to trademarks. So I won't say poo. I'll say PU. And so basically, you come in and say, this is awful. We're going to have a hard time enforcing this patent. And then there's antitrust violations, and the patent lawyers lose their licenses. OED gets a hold of them. They can't practice for the PTO. State bars disbar them. Ooh, you don't want to be there. I mean, that's what I'm hoping for the next 32 years. My goal is to not commit inequitable conduct because I like this. I like what I'm doing. And so there's one thing you can do, that if you get into this and it's a stinkeroo, not a poo, but a stinkeroo, you can do supplemental examination. And I've got whole sets of slides on that. If anybody wants to email me at tom.irving@finnegan.com, I'll send you my slides on supplemental examination. But it's one of the AIA acts. It was the only thing in the AIA that Orrin Hatch could get through because he was trying to get rid of inequitable conduct, because a company in Utah was found to commit inequitable conduct. So it was very important to Senator Hatch. So anyway, supplemental exam is alive and well, working quite well, and you can bring in all the things you screwed up. and say, oh, you know, I said this, but it really wasn't true. And now that we know what is true, here's why it really is patentable. And the beauty of this is if you do the supplemental examination, I call it the car wash. If you go through it, all the information you gave to the patent office, and you go through the car wash, then the statute says that information cannot be used as a basis for inequitable conduct in a litigation. Now, I say that. This thing came on board in 2012. How many cases has there been where there's been a judicial test of what went through supplemental examination? The answer is 0. So again, I'm happy. I'd love to support Howard. I love the students at Howard. I love Howard. I love Professor Matima. I would like to do this for 32 more years. Let's see how this develops. It's a developing area of the law. Okay, let's go. Last
Tom,
point. Yeah.
Just a 4-minute notice.
You don't need to worry. I'm on it. Let's go to, it's the of another, Ray. It's either your slide 46 or 48. It's the Transova case. Okay, Transova, yeah, one back. Back to the of another. It says of another at the top. If you can go backwards. Right there. Okay, now this is as fun as it gets in patent law, because here you get a patent. It names these inventors, but they put in data. And the data they put in is from a person named Green. And Green has this data. He works for Cogent. Well, they put the data in the application, but they don't name Green as an inventor. And so, Green gets left out. And so then there's this prior art reference, and it's Lou Cran Seidel, and it's also got the Green data table. So the question is, wait a minute, shouldn't Green have been an inventor? And therefore, isn't the Lou Cran Seidel reference of another, and therefore it could qualify as prior art and beat the whole darn thing? Well, this thing, if there's any muddy metaphysics in the muddy metaphysics of patent law, it's joint inventorship. Trying to decide who joint inventorship is, I can't tell you how much of the last 45 years I've spent working on knotty problems involving joint inventorship. So you have to look at this, and I thought the court had a very interesting take. They finally said, oh, Green was not an inventor. Gee, they never thought him important enough to put him in as an author, blah, 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 blah. But go to the next slide. And this is my closer. Okay, this is great. Oral hearing. Judge Clevenger. Now, I know about Judge Clevenger. Esther knows Judge Clevenger from her time as clerk at the Federal Circuit. Here's a person who says what he thinks. Because at one point, somebody in this crazy case called Allen Engineering was trying to argue that parallel meant perpendicular. And Judge Clevenger, he leans across the dais and he says, do you have any better arguments? You know when that happens, you're going down. You are going to lose the case, guaranteed. And so here, I got to leave you with this quote from Clevenger. He says, can I tell you something? In my mind, neither one of you wanted to know the answer. You didn't want to know whether Green was an inventor or not. And so you stuck your head in the sand. All you had to do was call up Cogent, and all you had to do was ask Mr. Green, well, hey, what happened? What'd you do here? But neither one of you did it. Shame, shame, shame on you. So who loses here? Of course, who loses? The party that had the burden of proof. And they went down in flames. Well, I've sure had a lot of fun being here. Sorry for the technical problems, but I guess it helped when I took off my beard and my wig. Things got better. So, Esther, I'm going to turn it back to you. I'm done.
Tom, thank you so much for that highly entertaining and magical presentation. Now everyone can see why Tom is the wizard. Thank you for that once again. We are trying to go back to Ian now. Ian, are you able to proceed? Ian, you appear to be muted.
We cannot hear
Yeah,
you.
no, sorry. Sorry, the conference automatically mutes me, so I just shared my screen and started talking, and I didn't realize that I had been muted. I'm glad that the judges don't have that ability, or I would be really in trouble when I appear in court by Zoom. Anyway, I'm sorry for the problems earlier. Let's get rolling. I've got a lot to cover. I've included some excerpts from my treatise in the materials on copyright fair use, and I believe also on preemption and 72 Copyright Act. I've not included my slides. I will provide them, but otherwise feel free to email me or to reach out to me in social media. I'll be happy to send you a set of the slides. Also happy to send you any excerpts from the treatise that I might not have included. There's a lot that happened in the last year. So let's start. First of all, there's a new amendment to the Copyright Act. The Case Act does a number of things. It creates a criminal provision for illicit digital transmission services. That was somewhat controversial when it was enacted, but I think that prosecutorial discretion will probably limit how it's applied. And there was the creation of a copyright small claims process, and that was discussed extremely well yesterday by Terica Carrington. So I'm not going to go over what she covered, but I think it's important to keep in mind that when it takes effect, which will either be the end of this year or June of next year, it's entirely voluntary. No one can be forced into this process. But if you choose this process, it is a lower cost alternative. Damages are capped. But of course, from a company perspective, from a defense perspective, there may be reasons to not use this process. So we'll see how it plays out. There were 2 U.S. Supreme Court cases this year in the copyright area. Georgia v. Public Resource, Inc. deals with government works. And of course, the Copyright Act provides that U.S. government works are in the public domain. There's a narrow exception to that when the government acquires works that were created privately, but that's a very narrow, esoteric exception. The open question had to do with state works, and here the state of Georgia claims a copyright protection on the official code of Georgia, annotated. It's actually created by Matthew Bender, which is a division of Nexus, and it's created as a work for hire for the Georgia state legislature.
Excuse me, Ian?
Yes.
You are sharing your screen, but it is not in presenter mode. I don't know if you're going through your slides, but we're still seeing the first slide.
Okay, it is in presenter mode, but maybe there's something we can do on your end because I have been running through my my slides, and that's obviously not very good if you can't see them. So why don't you run the slides? You can go through the first. Can you pull up my slides?
Yes, I can share my screen then and have your slides.
Okay, all right. And I'm going to keep talking because I'm very sensitive that we have a lot to cover and very little time. Once it's up, I'll tell you where to go. Okay, all right, we're almost there. So there's my email address, and I'm happy to send you the slides or reach out to me in social media. I'm also happy to send you excerpts from the treatise. If you go to the next 2 slides, you see screenshots from my website. And that's the website for the treatise. Let's go to the next page, which is where I was happily talking without any knowledge that you weren't seeing what I was talking about, which was the Case Act and the Supreme Court cases. So with respect to the Georgia v. Public Resource case, the general assumption had been that while state codes would be in the public domain, a state cannot prevent others from copying a legal enactment, that the annotations based on earlier case law, if they are created properly, have sufficient minimal creativity to be entitled to copyright protection. But in this case, the Supreme Court said that the entire work, including the annotations, were not entitled to copyright protection. And the reason is the issue was not the level of creativity in the annotations. The focus when you're dealing with government works is not on the nature of the content, but on the identity of the author. And here, because the work was done as a work for hire for the Georgia legislature cannot, under the government edicts doctrine, they cannot claim copyright protection in anything they do in their official capacity. So that's critically important. If they publish something not in their official capacity, I suppose that could be subject to copyright protection. For example, when a judge writes a book or writes a novel or writes their biography, that's not in their official capacity. But the government edicts doctrine protects anything when the government or a state government is acting in its official capacity. The interesting thing, of course, is if Matthew Bender had published this annotated code on its own, not as a work for hire for the state of Georgia, then it could have claimed copyright protection in the annotation. So an interesting issue. The other copyright case deals with a very narrow issue, state sovereign immunity, and the Supreme Court said that Congress potentially could abrogate state sovereign immunity, but they did not do it in the Copyright Act. The other development this year that was quite interesting is that the Copyright Office issued a Section 512 report. That deals with the Digital Millennium Copyright Act safe harbors for online service protection. I litigate those issues frequently for different Silicon Valley companies, and I actually testified in one of the proceedings. This goes back many years, and as you'll see in the report, I testified at the session held in San Francisco on May 12, 2016. And then it took another 4 years before the report came out. The report was issued by acting copyright registrar Maria Strong. We like Maria. She's a former Greenberg Traurig shareholder, and she left the firm to join the Copyright Office a number of years ago and served as acting registrar of copyrights before the new registrar Perlmutter was confirmed and has now taken over. And the new registrar testified just recently that the 512 report is something that the Copyright Office is focused on. It does not recommend any legislative changes to the DMCA, and it has been criticized in the tech community for characterizing the state of law in a way that is favorable to plaintiffs and somewhat unfavorable to service providers. It remains an open question whether and to what extent that report will impact things. There's also some pressure in Congress on both the DMCA and the CDA, the Communications Decency Act, which are bedrock provisions that protect online service providers, that allow the Facebooks and Googles of the world and YouTubes and others to operate without fear of being held liable for the alleged misconduct of users if they comply with the law. Let's move to the next slide, and I want to quickly talk about fair use. We can go on to the next slide as well. There have been a couple of interesting cases in this area. I should also apologize. I realize as we see this in Teams, the text is somewhat small. This is not intended to be your 2021 ophthalmology exam, but for those of you who feel that it is, again, I'm happy to email you the slides. Copyright fair use is determined by a multi-part balancing test. It looks at various factors, including the purpose and character of the use and whether the work is transformative. That is one of the most important parts of the test. This concept of transformativeness comes from a law review article by Second Circuit Judge Laval and has been recognized in U.S. Supreme Court case law. The other factor that's particularly important is the effect of the use on the potential market for the copyrighted work. It's a balancing test. Copyright fair use cases are the ones most frequently overturned on appeal. And if you line up a group of copyright experts with the same facts, you are often hard-pressed to find unanimity in many cases. So these cases are often hard fought and as I say, frequently reversed on appeal. It's a multi-part balancing test. You're not limited to the 4 factors. And in fact, I have a case pending in the Southern District of New York where we've argued for an additional consideration that we think is relevant. There's also a balancing, and then there also are factors that are considered presumptive, like scholarship and research. The case to watch for this year before the U.S. Supreme Court, Oracle v. Google. I can't really talk about that case because I worked on the case at the district court level representing Google, and so I can't really say anything except that I hope that the Supreme Court corrects the error of the Federal Circuit, but we will see at some point between now and the end of June. That deals with copyrightability and fair use of APIs, very important for software development, so watch that case. Bremer v. Violet Hughes, an interesting one for those of you in the DC area. Use of a stock photo of the Adams-Morgan area of DC copied from Flickr in response to a Google search to promote a film festival was not a fair use. The district court in Virginia had said it was, but actually the Fourth Circuit said no. And it really goes to one of the urban legends, if you will, about copyright law. A lot of people feel that if information is on the internet, it can be easily copied, it can be easily reproduced. That must be fair, and it must be in the public domain. And the reality is, it's simply because something's on Flickr doesn't mean someone doesn't own a copyright in it. The Dr. Seuss v. Comics case was an interesting one decided just a couple of months ago by the Ninth Circuit. And that involved a Dr. Seuss Star Trek mashup. Mashups are fun, they're interesting, people enjoy them, but they're not always fair use. And indeed, in this case, the Ninth Circuit found that it was not a fair use. Just because something is a mashup, just because that mashup may be creative, may be enjoyed by fans of Dr. Seuss or fans of Star Trek, does not mean that that it is transformative. In that case, the court found it was not transformative and that it adversely impacted the market. The court said, although comic mix's work need not boldly go where no one has gone before, its repackaging, copying, and lack of critique of Seuss, coupled with its commercial use of Go, do not result in a transformative use. Another interesting recent case, this was a district court case, Chapman v. Mirage. This involved music sampling, and the case was brought by Tracy Chapman, who is a fellow alum of Tufts. In fact, when I was there, she dated a friend of mine, and in those days, she used to go down to Harvard Square and sit on the ground and play music with her guitar case open. Nicki Minaj sampled one of her songs in a track called Sorry, and she repeatedly sought permission from Chapman, which Chapman repeatedly refused to provide. Now, the thing about fair use is you do not need permission, and the fair use doctrine protects you even when you ask for permission. But in this instance, permission was sought multiple times and was refused. As often happens in the music world, the song leaked to New York's Hot 97, and it was played. And so Chapman sued Nicki Minaj under her real name, which is Onika Mirage. And so the suit, Chapman v. Mirage, the court held that private sampling and experimentation was a fair use. I don't think this is controversial, but there also hadn't been a prior case like this, a high-profile case of a song leaking into the public. And so that's an important ruling. On the other hand, the court said it was a jury question whether Nicki Minaj herself had leaked the song and therefore could be liable for copyright infringement. Ultimately, the case settled. Let's go to the next slide, and I'm going to talk about preemption and common law copyrights. And we've got another hip hop case on the issue of preemption. Let's go to the next slide. The Copyright Act broadly preempts state law claims based on copying. And the case law is very clear. There has to be an extra element. And so this comes up a lot, for example, in the AI area with data portability and screen scraping. It becomes an important issue of whether database owners who can't really sue under state law for copying, and they're dealing with unprotectable facts, whether they can bring state law claims, and they can if there is some other element, like unfairness for unfair competition, for example, and they can't if the claim basically just comes down to copying. So In re Jackson involves that issue in an interesting twist in a right of publicity case. And frequently when you're dealing with content, you often have right of publicity issues that come up with copyright issues. In re Jackson involved Curtis Jackson, better known by his stage name 50 Cent. And in that case, Rick Ross sampled probably 50 Cent's most famous song, In the Club, for a mixtape entitled Renzel, which he used to promote an album. And interestingly, in that case, 50 Cent sued for Connecticut right of publicity violation. Now, why? Well, it may well be, and again, I'm just speculating here, but it may well be that the use of a small clip would likely have been found a fair use under copyright law, and therefore the hook that was used here was right of publicity. And right of publicity claims frequently are not preempted because there usually is another element. For example, if someone's name or likeness is used in a commercial advertisement, then you have that extra element. Here, the argument was that In the Club is such a famous song and so closely associated with 50 Cent that using that clip was the use of his voice. And indeed, Rick Ross did a shout out to 50 Cent. So the allegation was the name, the use of his name in that shout out, and the use of his voice in the clip from In the Club was a right of publicity violation. But the Second Circuit, in a decision by Judge Laval, it's a very erudite decision, and the analysis goes on for a good 21 pages in the Westlaw version, in the reported Westlaw version in F3rd, found that it was preempted because the claim essentially was for reproduction. The other interesting issue, which is litigated less frequently, but there was one important decision this year that I want to flag, deals with common law copyrights. The 1976 Copyright Act excluded pre-72 sound recordings. Now, the Music Modernization Act of 2008 brought those back into copyright protection. It's not now part of the Copyright Act, but it has analogous protection. But you have a number of pending lawsuits involving pre-72 sound recordings that were used between 1977 and 2018. The Music Modernization Act preempts certain retroactive claims where royalties were paid, and it preempts all claims going forward. But that leaves open a number of cases. And in a case that I litigated and won, Ponderosa Twins Plus 1 v. iHeart Media, we had an interesting decision from Judge Chabria in the Northern District of California. And the issue in a lot of these cases that I have on the board is whether there is a state law right of public performance, either under common law or by statute. Here in California, there was a statute in effect. And both New York courts, the New York Court of Appeals and the Florida Supreme Court, have found that there was no right of public performance under New York or Florida law. The issue in California is open, and it is before the Ninth Circuit in a case presently pending. And there was a district court case several years ago, Flo and Eddie v. Sirius XM, that held that there was an implied right. And I've argued that that is a wrongly decided decision. In the Ponderosa Twins case, I represented SoundCloud and Deezer, and we moved to dismiss, arguing that there is no implied right of public performance under California law. And Judge Chabria agreed with us and was not swayed by this other case, and ruled, even though there is a pending case before the Ninth Circuit, holding that the plaintiff was unlikely to state a claim, and that whatever the extent of common law copyright was in the 1960s, there's no indication that it included a right to prevent others from publicly performing a sound recording. Also, he held that whatever right existed was lost on publication. So an interesting issue. Keep your eyes on the Ninth Circuit decision to see if the Ninth Circuit agrees also that there is no right in California, as other courts, particularly in Florida and New York, have held. Let's move to the next slide and let's talk about copyright damages and attorney's fees. There have been some interesting decisions there too. So copyright owners may elect actual or statutory damages at any time prior to a jury verdict. This gives copyright owners an incredible hammer, and it is a problem for defendants, for people who are making, hoping to make fair use of works or otherwise, because it allows copyright owners to recover their damages, which are the greater of their own lost revenue, less expenses, and to the extent not duplicative, the alleged infringer's profits. Or they can get statutory damages, and statutory damages typically range between $750,000 and $30,000 per work infringed, but they can go up to $150,000 if plaintiff proves willfulness. This is one of the reasons that we've seen a lot of troll litigation in the copyright area in the last few years. If you go to Lex Machina or Pacer and look at the number of copyright cases that are filed each year, the largest number over the last 3, 4, maybe even 5 years have been brought by copyright trolls. Typically lawyers representing paparazzi photographers or others who are suing in gotcha cases where they're trying to get quick settlements because they know the cost of defense is significant, and they also know that that there is this hammer of statutory damages. Now, in the last year, some of those have been scaled back. One of the most notorious alleged troll lawyers has even been sanctioned and suspended from practice in a number of courts, but it is an ongoing issue. In the statutory damage area, a very interesting decision from the Ninth Circuit just last month. Let it not be said that the Howard IP Conference is the most current IP conference. The Desire v. Mana Textiles decision was decided less than a month ago by the Ninth Circuit, and it raises a very important issue. In the Ninth Circuit, copyright owners have been suing in the Ninth Circuit because of the Columbia v. Krypton case from 20 years ago that suggests that a copyright owner potentially can get more than one statutory damage award when a work is infringed if you have multiple defendants that are jointly and severally liable with a main defendant, but not jointly and severally liable with each other. And I know that sounds a little bit complicated. It involves essentially a hub and spoke relationship. Imagine, if you will, this was one case where I defended. I represented a motion picture studio that owned a user-generated content platform, and they were sued alleging this kind of damage, alleging that that my client, the motion picture studio, was jointly and severally liable with every single individual user of this user-generated video platform, and that the users were not jointly and severally liable with each other. And therefore, for a single allegedly infringing user upload, my client could be liable for, let's say, 100 statutory damages awards if there were 100 users. It is an incredible expansion of copyright law. It is advocated by Professor Nimmer in Nimmer on Copyright, which is a very noteworthy treatise. But I think it is absolutely inconsistent with the Copyright Act. So 20 years ago in Columbia Pictures, the Ninth Circuit agreed with Professor Nimmer, and in that case, you had a single broadcaster, and you had two television outlets that issued or that showed the same television show, and so the court found that there are two awards in that case. The statute says an award of statutory damages may be recovered for all infringements involved in an action with respect to any one work for which any one infringer is liable individually, or for which any two or more infringers are liable jointly and severally. And so the Ninth Circuit 20 years ago adopted this hub and spoke theory, meaning that a single defendant could be liable not just once in one action, but many times over and over and over again if that defendant was jointly and severally liable with other alleged infringers who were not jointly and severally liable with each other. And this is especially problematic in the online world, where you could have one site allegedly jointly and severally liable with all of its users who were not jointly and severally liable with each other. Now, about 4.5 years ago, the Ninth Circuit scaled this back in Friedman v. Live Nation, saying that multiple works are only available when downstream defendants are actually sued. So you need to sue them in the same action. Well, Desire v. Mana Textile was that case. A fabric supplier, and fabrics typically are entitled to very thin protection. I've litigated those cases, and actually in one interesting case I had, it turned out the design was not created by the plaintiff. We found it in books from the 1800s. But in any case, this design owner sued many defendants, manufacturers, retailers, and sought multiple awards, and said to the court, this is not like Friedman, where you have multiple infringers who are not before the court. They're all in this court. Well, in a 2-to-1 decision with a strong, angry dissent, the Ninth Circuit less than a month ago held that there could only be one award, because in this language, an award of statutory damages may be recovered for all infringements involved in an action with respect to any one work for which any one infringer is liable individually, or for which 2 or more infringers are liable jointly or severally. The court focused on the language there of in the action, and the majority said that because this is one lawsuit, there's only one award of infringement. Now, the troubling part of this decision is that both the majority and the dissent agreed that if the plaintiff had filed multiple lawsuits, that under the hub and spoke theory of Professor Nimmer and Krypton Broadcasting, that they could recover multiple awards. So a petition for en banc review is likely to be filed. And if there's en banc review, or if there's a Supreme Court decision, they could reverse the Krypton case. But short of that, Krypton remains good law in the Ninth Circuit. And I don't think there's much chance for Supreme Court review here, because there is not a split in the circuits. But I tend not to predict what the Supreme Court will do. I had a copyright case before the Supreme Court in 2010. The Muchnick decision, we won 9-0, and yet they found a way to rule for us that the case continued in litigation for another 9 years. We had another Second Circuit decision. We were before the district court. So I've learned not to predict what the Supreme Court will do. One final point here: attorney's fees. The Ninth Circuit held in Doc Stream for the first time that a declaratory relief plaintiff can recover attorney's fees. Let's skip 2 slides, and I know I've only got 3 minutes, so I'm going to go quickly. Linking and framing. There's been a lot of litigation in the last 2 or 3 years over linking and framing. For many years, we thought the law in this area was settled. The Ninth Circuit decision, Perfect 10 v. Amazon, adopted what was called the server test. A link, as you know, is simply an instruction from a browser to go from one location to another. It doesn't actually make a copy. I argue in my treatise, and the Ninth Circuit took the same analysis in that case. But let's go to the next slide. There's been a lot of litigation over embedded links in social media. Here's an example where you have a Washington Post article, and they embed a Twitter post where you see a photograph. Now, the Washington Post has not copied this photograph in the sense of reproduction or distribution, in my view. All they did is there's a little piece of code that's an instruction to a browser to go from one location to the next. Let's go to the last slide. I know I've only got 2 minutes, so I've got to go quick. Several district courts in the Southern District of New York have disagreed with the Ninth Circuit, and they don't agree with Perfect 10, and they say, well, putting aside reproduction or distribution, when you're dealing with a photograph, that's a public display. Now, they don't really go at the analysis that I just gave, which I think is the defect in these cases, but they've been followed over and over again. And so you now see dozens and dozens and dozens of lawsuits in the New York courts involving embedded links in social media. The two cases I want to highlight in the 1 minute that remain are fair use cases, Boson v. United Sports and Walsh v. Town Square. If you've got a news article, let's say that you are writing about you're writing about 50 Cent and about the lawsuit. If you copy, if you embed a link to a story that has a picture of 50 Cent, that's probably not a fair use because you're using it for some other purpose. But if the news story relates to the social media post, as so many news stories about celebrities do, as in Boson, as in Walsh, then it's a fair use. But I hope this will eventually get up to the circuit court because, as I argue in my treatise, and as the Ninth Circuit holds, I don't think this is a public display to begin with. But I will say, when my treatise has been cited by courts, it's often cited for the opposite proposition that it stands for, meaning that a law clerk somewhere needs a site and they find it on Westlaw, but they don't cite it for the right proposition. I'm out of time.
Thank you very much, Ian.
Yeah, I'm out of time, so thank you.
We have to close at this time. Thank you so much for your very interesting presentation on copyrights. Deep thanks to the entire panel, Tom, Chip, and Ian, for the fabulous year in review of significant IP cases. For PowerPoint slides, please use the registered attendee link to the conference website or connect with Tom, Chip, or Ian through LinkedIn. Thanks again for joining us.
Bye-bye. Thank you.